Welcome to From Our Perspective. I'm joined by civil litigation partner Eric Keivel to discuss a homeowner's battle against their HOA. Our client is a disabled veteran who needed a wider driveway for a wheelchair. The Homeowners Association had a problem with the changes they made to their driveway, and it led to a long legal battle. Our team was successful at trial and the appeal. Eric, thank you so much for joining me today. Tell me more about our client and why they reached out.
Our client reached out to us because the husband needed wheelchair access to park in his driveway, and in order to do that needed to expand their driveway. The clients had gone to their HOA to seek approval. As in most cases, when you're making changes to your property, you've got to go to your design control committee of your HOA and get approval. They did get that approval on several different sets of plans, got the driveway expanded, and lo and behold, after they completed the project, they got a nasty letter from the HOA saying that the improvements that they made weren't in conformity with the conditions and restrictions of the HOA, and that if they didn't tear out the driveway they'd just put in, they were going to get sued. So they came to us to defend against the HOA's claims against them.
And what evidence did the HOA have that our client's driveway was too close to the property line? Was that the main issue?
Well, there were two issues. One, the HOA documents provided that the maximum width of a driveway could be 28 feet, and also that it needed to be 4 feet setback from the property line of the adjoining property owner. In this case, there was no dispute, no legitimate dispute anyway, that the driveway was wider than 28 feet. There was a dispute over how close it was to the property line. The HOA measured and said it's too close, but the judge found that the HOA didn't establish where the property line was from which they measured, and so the judge sided with our client and allowed them to keep the driveway as is.
And what was the outcome of this case and the appeal?
Well, the HOA didn't like the judge's decision, and they took an appeal to the Court of Appeals. The Court of Appeal upheld the judge's decision entirely, and again, the clients were allowed to keep the driveway as is.
And after such a long legal battle, what was our client's reaction to winning this lawsuit?
Well, the client's always relieved whenever they can resolve a dispute with their HOA. I think this particular client would have preferred not to have to go all the way to trial and to an appeal, but if that becomes necessary, that's something we at Robinson and Henry are more than prepared to do in order to protect our clients' interests.
And if someone is watching and they are in a dispute with their HOA, what advice would you have?
Well, the first thing to do is make sure you're complying with the conditions, covenants, and restrictions of the HOA. Those are documents that are made available to you whenever you buy a property that's subject to a homeowners association. If you don't have a copy of them, you can also get a copy from your HOA or their management company. Review those carefully and make sure you're in compliance, but the HOA has to be in compliance as well. So if they're operating outside the bounds of their conditions and covenants, that's something you should come and talk with a lawyer about to walk you through the process, because there are things that HOAs try to get away with that they're not allowed to do.
Great advice, Eric. Thank you for sharing your perspective.
Thank you for having me today.
If you're fighting your homeowners association, just know it's not the end of the road. Our team of experienced HOA litigation attorneys can help. Reach out to us for a case assessment on our website or give us a call.